They confirmed Neil Gorsuch.
Brett Kavanaugh has been confirmed.
Judge Amy Coney Barrett confirmed in record time.
Barrett also shifts the court to a 6-3 conservative majority.
Mitch McConnell had already told Republicans that Democrats won't be able to do much about this for a long time to come.
Hello, everyone. Good morning. For some of you, it's really early, and for the rest of you, it's like mid-morning. But either way, thank you so much for joining us this morning. My name is Tamara Brummer, and I'm the Senior Advisor and Director of National Outreach and Engagement at Demand Justice. Thank you all again for joining us for this important Netroots Nation's panel on expanding the Supreme Court to protect abortion rights. I want to start off by thanking Netroots for hosting us, and a very, 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 very special thank you to our incredible co-sponsors, All Above All, Ultraviolet, We Testify, and Women's March for being such great partners in this fight. So before we jump in, I want to give a bit of context about how we arrived at this conversation. As many of you know, Republican politicians led by Senate Minority Leader Mitch McConnell have run a decades-long win at all costs campaign to install a solid conservative majority on the Supreme Court. In order to achieve that goal, the Republican Party broke every norm and convention in the book by blocking President Obama from appointing a justice for nearly a year, lowering the threshold for confirmation of Supreme Court justices, sweeping under the rug credible allegations of sexual assault, and rushing to confirm President Trump's last nominee in the final days of the 2020 election, after more than 60 million Americans have already voted. So as a result of this scorched earth politics, the Supreme Court's majority is now wildly out of step with the everyday Americans it serves, ruling almost exclusively in favor of corporate and Republican Party interest. The immediate effect of the court's newly fortified conservative supermajority is perhaps most obvious in the context of abortion access. Just last month, the Supreme Court refused to block a flagrantly unconstitutional Texas law that bans abortion after 6 weeks of pregnancy. And Roe v. Wade has been functionally overturned in our nation's second largest state, each of the 38 days since then. Later this fall, the court will consider another case from Mississippi that could further erode the constitutional right to abortion or end it nationwide altogether, upending 5 decades of precedent and going against the judgment of a consistent and commanding majority of Americans. It's clear the Supreme Court poses an imminent threat to our right to make decisions about our bodies, our lives, and our futures. And we know that the impact of the court's decisions will be felt most acutely by people of color, people with low incomes, and other populations that already face significant barriers to accessing adequate health care. That's why we can't afford to wait to address this threat. Today, we'll talk with reproductive rights, reproductive justice, and court reform advocates about why we must add seats to the Supreme Court in order to protect our fundamental rights and clear a path for progress towards a more equitable future. All it takes to expand the court is a simple law passed by Congress, the Judiciary Act of 2021, which will add 4 seats. Here to get us started on this conversation and to provide some insight into how we ended up at this point and where we go from here, we are so privileged to be joined by one of the champions of this legislation, Congresswoman Ayanna Pressley. Congresswoman Pressley has represented the 7th District in Massachusetts since 2019, when she became the first Black woman ever to represent the Commonwealth in Congress. She serves on the House Committees on Financial Services and on the Oversight and Reform, and she chairs the Abortion Rights and Access Task Force of the Pro-Choice Caucus. She founded the Black Maternal Health Caucus and is a member of the Caucus on Black Women and Girls. Congresswoman Pressley has been deeply committed to reproductive justice throughout her career, and most recently co-leading the push for the Women's Health Protection Act with Representative Judy Chu. She has also become one of Congress's strongest voices on Supreme Court reform, leading the fight to hold Justice Brett Kavanaugh accountable when the Senate failed to properly investigate him during his confirmation hearings in 2018, and becoming one of the first co-sponsors of the Judiciary Act of 2021. Which would safeguard our fundamental rights, restore the court's legitimacy, and bring balance back to a bench that's become dangerously unbalanced. So let's everyone join me in welcoming Congresswoman Pressley.
Thank you. Good morning. How are you?
Good morning.
It's good to see you.
I was so excited. I'm like, yes, it's so good to see you as well.
Well, I'm happy to be here, and thank you for that kind introduction, and thank you to Demand Justice for convening this session, bringing us all together. This is an incredible panel of repro justice warriors and abortion storytellers that have come together this afternoon. All of these battles are intrinsically linked. If you care about voting rights, if you care about housing rights, if you care about combating gun violence, ostensibly, if you care about justice and freedom in any iteration, including reproductive freedom, you should care about court expansion, because these issues are intrinsically linked, and we must do everything in our power to restore balance to the court and to ensure that the Supreme Court is actually working on behalf of the people. Because right now, they have been ruling with the absence of justice, and they have not been on the side of the people, which is exactly why Congress has had to step up and to stand in the gap. But we need to expand the courts. So it is an honor to join you at this virtual table today to talk about how we do that. Very proud to be your sibling in the movement and the work of justice. And I'm glad to be here and eager to get started.
Awesome. Thank you so much. We couldn't be more proud to stand next to you in this fight. So I have a few questions for you this morning to really get our conversation started. So as you know, 2021 has been the most devastating year for abortion rights since the Supreme Court guaranteed the right in 1973 in Roe v. Wade. What's happening in Texas with SB 8 is just the most extreme version of what's happening in states across the country. What do you think is motivating these laws, and what will likely be their effect?
Yeah, well, I mean, this is the culmination really of a decade's worth of calculated and coordinated attacks. It's been really sort of a slow boil, if you will, from anti-abortion lawmakers across the country. It is exactly why elections matter at every level. SB 8 and the other state bans and restrictions, again, have been a coordinated and growing attack from our state legislatures. And let's be clear, the catastrophic consequences have always been targeted on our most vulnerable. By creating these bans and these restrictions, it certainly doesn't mean that all birthing persons will stop having abortions. It simply means that what we're pushing out of their reach are safe, necessary, legal abortions, medical care, abortion care, which is health care. And we're putting it out of reach for our most vulnerable, our lowest income sisters, our queer, trans, and non-binary siblings, Black, Latinx, AAPI, immigrants, disabled, Indigenous people. And none of this happens by happenstance. It is all very precise. So like the roots of the anti-abortion movement, you said, what's the motivation behind this? At the root and at the core, it's what is at the root of most injustices that seek to exact precise harm on the most vulnerable: patriarchy and white supremacy. And that's true whether you're talking about SB 8 or you're talking about federal coverage bans like the Hyde Amendment. So these anti-choice lawmakers, they're motivated by one thing and one thing only, and that's finding any way possible to chip away at abortion rights as they await their chance to capitalize on an ultra-conservative majority on the Supreme Court to overturn Roe v. Wade, settled law that 80% of Americans don't want to see overturned. So we see this playing out right before our eyes. And SCOTUS is now scheduled to take up the Mississippi 16-week ban law in the matter of weeks. And this law was intentionally crafted by Republicans to reverse Roe v. Wade. So the stakes here just keep getting higher, honestly.
No, absolutely. And thank you for connecting the dots, right? Like abortion bans don't come in a silo. It's a part of a broader strategy rooted in white supremacy and patriarchy. So you recently spoke before the House Oversight Committee, and you said abortion care is a constitutional right, and that Congress and the White House must do everything possible to protect and guarantee it as such. I couldn't agree more. Can you tell us why this issue is so important to you, and to your constituents, and to their communities?
Sure. Again, the injustices are coordinated, precise, codified in our laws, sadly strengthened by our courts. It's all intersectional, the injustices and these fights. So I see the fight to protect abortion rights and to advance reproductive freedom as an economic justice issue. I see it as a racial justice issue. And so when we say that we're in the midst of a national reckoning on racial injustice, that has to mean something. If that is true, then the only receipts that matter in this moment are policies and budgets, and how intentional and unapologetic we are in dismantling systems of oppression and taking a stand against discriminatory policies wherever they exist. Since our nation's founding, those in power have created these systems and structures of oppression, again, that have exacted very precise intentional hurt and harm on our communities, particularly on Black women and women of color. And those structures have dictated who receives critical, high quality health care. Wealth, and who, by virtue of those resources, has the most basic right to bodily autonomy. So I believe we have to be just as precise in legislating equity, in legislating healing, in legislating justice as those powers that be have been precise and intentional in exacting hurt and harm. And then certainly, just as I close, I'll say as a Black woman, this is personal. We have a Black maternal morbidity crisis that continues to rob us of Black mamas at nearly 3 times the rate of white women. My paternal grandmother, who I never had the privilege of meeting and getting to know, she died in the 1950s, giving birth to my father's youngest brother. And so the fact that, here we are in 2021 and Black women would still be 4 times more likely to die in childbirth or in post-delivery complications is unacceptable. So when we push comprehensive reproductive health care out of reach, including abortion care out of reach, it really only stands to exacerbate these health disparities. It compounds the economic insecurities that so many Black and brown communities are experiencing, especially in the midst of an ongoing pandemic, which has wrought unprecedented, disparate trauma onto our communities. Our communities have bore the brunt of this pandemic-induced recession. And we're the ones that stand to lose the most in this fight to preserve a constitutional right, which is abortion care, which is health care. So from El Paso, Texas, to Jackson, Mississippi, to Somerville, Massachusetts, our destinies are truly tied.
Absolutely. And thank you so much for sharing that about your family. I think that this is an issue that impacts so many of us in so many ways. And as we were talking about legislation, you along with your colleague, Representative Chu, are a co-lead of the Women's Health Protection Act, which recently passed the House. Can you briefly tell us what that legislation will do?
Absolutely. Just for a quick digression, I just want to say that, representation matters. And it doesn't matter, for photo ops or so we can pat ourselves on the back about how much progress we've made. The reason why you need a diverse representation of lived experience has everything to do with the power of the lawmaking pen. It's about the impact that it has in our policy. So I just want to acknowledge Congresswoman Judy Chu, who has been since 2013 introducing the Women's Health Protection Act, because she knew a moment like this would come. when we would need to fight this fight and take this battle on and to codify Roe v. Wade on the federal level. And so I want to thank her for the power of her representation, thank her for her leadership. And so the Women's Health Protection Act, WIPA, simply put, it will establish in federal law the right for doctors to provide individuals to receive abortion care free from political interference and medical unnecessary restrictions and bans. So it's just codifying Roe v. Wade on the federal level, affirming bodily autonomy, and a pregnant person's access to abortion care should not depend on where they live. So what WIPA does is it ensures that this right is enshrined in federal law, no matter how enshrined in federal law for everyone, no matter how you show up in the world, and that your access to abortion care, which is health care, not be dictated by geography. So it's codifying Roe v. Wade on the federal level, and then it's banning the introduction of state laws like the one in Texas. So Congress must act. We passed this bill out of the House, and I just want to take another moment of privilege here and to speak to the power of representation, not only in elected officials, but in our offices. And I want to give a shout out to my legislative director, a proud Latina, Aisa Conchola, who was really instrumental to it being possible for us to get WIPA to the floor for a vote. We had to whip those votes. And so I want to acknowledge her laboring in love to advance reproductive freedom and justice. So the House has passed the Women's Health and Protection Act, and now I'm calling on Senator Schumer to bring WIPA to the floor for a vote. We should abolish the filibuster to do so. And we need to get this bill to President Biden's desk for signature. So we can't stop with WIPA. We also need to pass budgets that are clean of the racist coverage bans like the Hyde Amendment, which I referenced earlier, and finally affirm that abortion care is a fundamental right that must be guaranteed to all.
Yes, that's so true. Thank you for your leadership on that, and to your team's leadership and vision on that work. Once we pass WIPA, we also need to think about the Supreme Court, which is what brings us here today.
That's right.
Can you tell us why you decided to endorse this idea of court expansion, and how in particular you think it's necessary to protect abortion access and expand reproductive justice?
Well, again, as I was saying in my top remarks, that the extremism of the Supreme Court has proven time and time again that they are not on the side of the people. Whether you're talking about voting rights, whether you're talking about housing rights, whether you're talking about reproductive freedom, they are in fact obstructing justice. And so we have to balance out the extremism of these Supreme Courts. Over the last several years, we've witnessed unprecedented efforts by Republicans to stack the court with hostile justices that are truly only interested in advancing a far-right partisan agenda. And we continue to see the drastic and adverse consequences and impacts of that on real people. This is incredibly consequential. And so I was very proud, and I commend Congressman Johnson and Jones for their leadership in this regard. I was proud to join them as a champion to the Judiciary Act, because we need to be exploring every legislative option on the table to restore a balance to the court and to ensure that SCOTUS is back in the business of exacting justice. And the fact is that the Constitution leaves it to Congress to set the number of Supreme Court justices. So it's within our bandwidth and our jurisdiction, and it's also not precedent setting. We've done this before. We've done it 7 times. People don't know that. They try to marginalize and radicalize this issue and make it as if it's some sort of fringe solution. But we have the authority, and we have the precedent of history on our side. So faith in our government is at stake, and the fight to preserve our democracy is at stake. The fight to preserve our fundamental rights are at stake, whether you're talking about abolishing the filibuster or expanding the courts.
That's absolutely right. We need to use every tool on the table to protect and defend our democracy. At Demand Justice, we launched an ambitious organizing program this year to really talk to your colleagues so they can hear directly from their constituents about how important it is to co-sponsor the Judiciary Act and expand the Supreme Court. And one of our asks for our friends here at Netroots Nation who have joined us today is to join us for our lobby day on October the 26th in Washington, D.C. Could you talk to us about why it's so important to organize and how your constituents' opinions inform the positions you take on this legislation?
Sure. First, I just want to say how much, and I've said this before, as someone who's an only child who grew up in an activist and organizing household. May my mother rest in peace and power. She was, she played many roles in community and in society, but the one that is the most defining for me is that she was a tenants' rights organizer. And so I grew up in an organizing household, and I grew up in a movement building household, and I love the chosen family that we find along the way, people aligned in one common purpose and goal. So movement building and organizing is essential. That's why I'm here today. I've always maintained, because my mother role modeled this and taught me this, that the power of the people has always been greater than the people in power. And some see that as a contradiction because technically I'm in a seat of power. But I'd like to think that the reason I'm in that seat is because I know where the real power lies, and it's with the people. I wouldn't be in this seat were it not for the power of people-powered movements. They've always been at the forefront of transformative, substantive social change. And I think, our sibling in the movement, Latasha Brown, really says it best when she says that organized power is realized power. So, that's why we can't let up.
Thank you so much for that. And so my last question for you, you've given us so many great gems already, but I think that in this moment, this can feel very hopeless, this fight to protect our bodies and our democracy. Can you offer some hopeful words to those of us who are out here on the front lines protecting and defending our democracy right now?
Yeah, well, I'll quote another sibling of the movement, a dear friend, Brittany Patnack Cunningham. And it's something that she said at the height of the pandemic, which I've internalized. And it's a quote that I revisit often. And she said that, I choose to practice the discipline of hope over the ease of cynicism. And it was a reminder to me that hope isn't this organic thing. It is a discipline. It is something that has to be practiced. And, whenever I feel defeated and weary, I lean on the strength of this movement. That's what emboldens me. And the stories that we've heard and the hardships that we see up close and personal every day. No doubt about it, the challenges we face are steep, but I believe our responsibility and the opportunity is far greater. We have to stand in the gap. And again, there's joy in this work, in the work of community building and movement building. There's radical joy in the work of system change and transformation. I think people often misunderstand our righteous rage and indignation at these injustices, but that righteous rage is rooted in radical love. So it's the radical love, it's the righteous fights we take on, it's the strength of our movement family that keep me going. And it's the reminder that hope is a practice and it is a discipline. So I do, just as I close, I want to show some love to the movement and thank all the organizers, the activists, the disruptors, the agitators, the persisters and champions in the fight, like Demand Justice, like Congresswoman Chu, my big sister, Congresswoman Barbara Lee, our colleagues on the pro-choice caucus. This is the first pro-choice majority Congress in the history of Congress. And because of the work that we did, we passed a funding bill free of abortion restrictions like the Hyde Amendment and like the Helms Amendment. That's been work that's been in the works for many, many years. But we finally have a pro-choice majority Congress, and that is more than a talking point. It means something. We've passed WIPA. We passed a funding bill free of abortion restrictions like the Hyde Amendment, like the Helms Amendment. And that is all a testament and a strength to the movement. None of this happened overnight. As Coretta Scott King reminds us, freedom is something that we earn in every generation. So, I seek to be more than an ally to all of you. I seek to be a co-conspirator in the work of justice. And I'm proud to do this work alongside you as we continue to not only change the narrative, but to change consciousness and to change laws and to change our country. I also want to say the great thing about movement building are all the people you meet along the way that you are aligned in the work of justice, but other things too. I just want to do a shout out to Eric, who did a shout out to Howard about eating some gooey butter cake. So, I say policy is my love language, but so is cake. Michael Harriet did a tweet this morning that said, can we normalize pound cake as birthday cake? Who is about that? Okay. I am about that.
I've never made a piece of cake I didn't like. So yes.
I'm trying to listen, and I'm trying to tell you, wherever they say, in organizing spaces, if you feed them, you can lead them.
A word.
Okay, so I can't wait till we can all be together in person, and I'm gonna make sure we have some good cake there. I'm talking about some 7-Up cake. Who know about 7-Up cake?
Okay,
anyway,
Congresswoman, we could be here all day talking about cake. Yes. Sign me up for that meeting.
But protect Roe, expand the court, and don't ask for justice, y'all. Demand it. Okay? All right. Thank you, Tara. Good to be with you.
Thank you so much, Congresswoman. I think that just goosebumps, and also I think something that just resounding is like, these things are not coincidences. We work really hard. We organize very hard in our communities, with our neighbors, with our families, to make these wins possible. And that also we are winning, right? And that having hope that we can win more is what this is all about. So thank you once again for being a champion and a partner and a conspirator along this journey.
You got it. Appreciate you, sis. Take care, everyone.
Wow, guys, folks, that was amazing. I have goosebumps. I just wish we could all be in person so I could hear the cheers and the applause right now. So I just want to thank the Congresswoman again for making time for us for this very important conversation, and her leadership in this really critical issue and time. So I'm also even more excited to be able to talk to our panelists who are joining us today. But before we jump into questions, I just really want to introduce this dynamic group of folks that are joining us today. First, we have my colleague, dear colleague, Katie O'Connor, who is Deputy Chief Counsel at Demand Justice. And prior to joining Demand Justice, she was advanced progressive legal issues at the American Constitution Society, the Advancement Project, and the ACLU Voting Rights Project. We also have Kelsey Ryland, Federal Strategies Director at All Above All, previously the policy manager at ERODE, which is Unite for Reproductive and Gender Equity, where she first began as the Law Students for Reproductive Justice Fellow. We are joined also by the distinguished Renee Bracy Sherman, founder and executive director of We Testify, who also served for 4 years as senior public affairs manager at the National Network of Abortion Funds. She's executive producer of Ours to Tell, an award-winning documentary by We Testify and Planned Parenthood, elevating the voices of people who've had abortions. She's popularized the phrase, "Everyone loves someone who had an abortion," coined abortion-splaining, and created the Ask About Abortion campaign, which led to presidential candidates being asked questions about their plans to increase abortion access. And last but not least, I'm grateful to introduce Sonia Spoo, Director of Reproductive Rights Campaigns at Ultraviolet, former outreach associate at Catholics for Choice, and her advocacy focuses on the intersections between faith, gender, and race. So give our panelists a round of applause, some love on the screen if you can see them, some hearts in the chat. But I really want to jump in and get started by asking this group some questions. And we'll also try to make time to have questions at the end for our audience, but also we'll be in a virtual meeting room after this that you can find on the platform where you can ask some more follow-up questions we aren't able to get to you today. So my first question is for Kelsey. Altogether, states have enacted a staggering 1,300 abortion restrictions since Roe v. Wade was decided in 1973, and more than a third of them have been passed since the beginning of 2011. This year, though, has shaped up to be the worst year yet, with more abortion restrictions being enacted than in any other single year. Can you tell us about the trends and general landscape of abortion access in the United States in the past decade or so?
Yes, and I will admit that I'm not going to do a full landscape because I want to not talk for too long so we can have some really good time for question and answer. But, I think I would be remiss if I didn't start with talking about the original abortion ban, the Hyde Amendment, which was passed shortly after Roe v. Wade became law. So Roe v. Wade became law in 1973, and then in 1976, the Hyde Amendment was passed. For folks who don't know, the Hyde Amendment bans insurance coverage of abortion for people who are enrolled in Medicaid health insurance. And we know that this disproportionately impacts low-income folks, BIPOC communities, LGBTQ people, young folks. It's truly a discriminatory ban, like the Congresswoman said. But let's fast forward several decades to 2010, when Republicans swept state and federal elections through gerrymandering and voting restrictions. And we've really seen an astronomical increase in abortion bans across the states. Before I review what some of those bans look like, I think it's worth saying that this year, I feel like I need to frown when I say this, has seen the most abortion bans enacted on the state level since Roe v. Wade. So 106 restrictions have been enacted in 2021. This is the first time that the number of restrictions has hit triple digits. It's really quite staggering. And our colleagues at Guttmacher have a great summary on the analysis if you want to take a look there, which will be much more in depth than what I'm going to share. But some of the bans that we've seen are trap laws, so targeted restrictions of abortion providers. These are laws that really require abortion providers, abortion clinics to meet standards that are medically unnecessary. So having a certain width in a hallway, having admitting privileges in an area where hospitals might be ideologically driven and won't grant admitting privileges to abortion providers. And abortion providers don't need admitting privileges at hospitals because abortion is an extremely safe procedure. We see gestational ban limits. So what we see in Texas, which is a ban at 6 weeks, what we see in the Mississippi case, a ban at 15 weeks. And these bans, first of all, 6 weeks is ridiculous. Most folks don't even know that they're pregnant at 6 weeks. And when you look at bans later in pregnancy, those are really challenging for low-income folks who oftentimes have to raise the funds out of pocket for their procedure because of bans like the Hyde Amendment. And then we see things like waiting periods. So someone's going to have to drive to a clinic, get mandatory counseling that's often medically inaccurate, wait 24, 36 hours, return to the clinic to have their procedure. For folks who are working for hourly wages, missing income like that can be devastating on top of having to pay for a procedure. And then we've started bans on medication abortion because the FDA has said that they're going to review the sort of regulations on dispensing medication abortion, which currently are ridiculously onerous. Someone has to go to a clinic, be given their pill, take it in the clinic, be given pills to then go home and take 24 hours later. This is something that can be done through telemedicine. And the FDA is reviewing those regulations right now, but states are quick to be banning medication abortion as a form of legal abortion and also banning telehealth as an option. I really want to go through all of these. I'll wrap up. But we also see state level insurance bans, so bans on insurance plans sold on the marketplaces, state employer insurance not covering abortion, and then finally trigger bans. So states who have bans on the books that say if SCOTUS strikes down Roe v. Wade, abortion is illegal in this state. There's plenty of resources online where you can see which states have those trigger bans, but the anti-abortion movement has truly chipped away access to abortion to make Roe v. Wade basically a promise in name only, particularly for low-income communities.
Thank you so much, Kelsey. That was a really thorough, although you feel like it's not complete rundown of what's going on, is super informative and helpful. So Sonia, the pace of these anti-abortion laws and their boldness seems to have increased over the last few years. Who's behind these laws, and are they reflective of the will of the American people? Do you think the changing ideological balance of the federal courts and the Supreme Court in particular has played a part in this acceleration?
Yeah, I mean, I think the way I kind of think about the past, frankly, like 50 years is kind of like, I'm a violinist. And so I think about what's been happening as kind of like the worst 5-movement symphony you can think of, right? So the fact of the matter is that the far right conservative actors have been working since Roe was passed to recenter white supremacy, to recenter all the things that they felt they lost in the civil rights movement and the subsequent cases that we saw across the court on LGBTQ rights, environmental rights, abortion rights, so on and so forth. They want to recenter, re-grab their power that they feel they've lost, and they've been doing that through these organized efforts that are kind of now in their final movement, like the 5th movement of this terrible symphony. And we've talked a lot about, like, Tea Party, what happened in 2010, and that was kind of like, to me, the 4th part of this movement, but now we're kind of entering into this end game, as we're seeing with SBA, and now that they have power of the courts. But they started this organizing, in the late 70s to recapture both local government, state government, and then kind of the last piece of their chess, like their queen, being the courts. And so these are far-right extremist actors who are highly organized, highly funded, and networked, who have worked over the last 50 plus years to get to the position now where not only do they have significant power at the state level and also the local level, because we don't talk about school boards and how these things all work together when it comes to restricting reproductive health care overall, but also now the judiciary, by packing the courts under former President Trump, and working to not only pack the courts, but to get into the courts very extremist and partisan, ideologically driven actors, some of whom were not even well qualified for the bench, period, as a way to enact their agenda against the majority of the American people's desires, wills, and needs. We know, as Congresswoman Pressley alluded to, that people support legal abortion. The media likes to portray this as like a equally both sides kind of thing, but we know that the majority of Americans support legal abortion, that it's not even close, and that these actors working, these political actors, their financial backers, both in corporate America and across the spectrum and media and stuff, are working to enforce an agenda that is contrary to the wills and needs of the American people across the board. Of course, they do this by going after, as the Congresswoman said, those who are most vulnerable among us: LGBTQ people, young folks, indigenous folks, people of color, and by using all the levers of power that they've gained, especially after 2010, to find different ways to kind of wedge these issues in, even if at the state level people don't support these issues. There's kind of this feeling that I hear sometimes that we just disregard red states, as if people in red states are somehow a monolith who are not dealing with the direct impacts of these policies, and that those people tend to be people of color, especially, right? And that we don't look at how these states are not just states that are red or blue, whatever these kind of distinctions that we draw are, but they're states that have seen their rights rolled back when it comes to rape suppression, abortion rights, all those things, in a systemic way that makes it harder for them to organize to push back, right? And so what I think we've seen now is that the courts, under the court packing scheme that McConnell and Trump were able to put into effect, are now more amenable to increasingly more extreme bans. Although, to be clear, any ban against abortion or any restriction on abortion is extreme. Anything that is intended to restrict a right is extreme by nature. But we're seeing laws that even 10 years ago, like a 6-week ban, would not have been given serious consideration in many states, now being passed into law because the courts have been so packed by the far right, by McConnell, by Trump, and by all their actors in that, that there's now signaling that these kind of laws that might have been, enjoined at least, or stayed, or even just overturned flatly on their face, now have a viable path to being just at least staying on the books for a while, and maybe even going into effect like we saw with SB 8. And because Trump was able to pack the court with 3 additional justices who are just deep partisan ideologues, who have shown a complete and wanton disregard for precedent when it comes to abortion access, and a total willingness to overturn abortion care overall, and to read a very expansive view of Casey and what undue burden is. Now courts are beginning to kind of see the winds of change that have shifted at the Supreme Court, and that has downstream impacts. It means the other federal courts are more willing to let things go or let things stand that they would have normally, struck down. It means that legislatures are more emboldened to pass increasingly more extreme bans and restrictions. And it means that the impact is becoming even more real for people every day in terms of accessing care. To be clear, Roe was always the floor. It was not the ceiling. Before SB 8 passed, before any number of restrictions that passed in the past, 5 years were passed, people still struggled to get access to abortion care because of Hyde, because of other restrictions in place. And these were all restrictions that were planned and coordinated through different policy shops across the country that all kind of did model legislation that they then worked to pass by gaining power through gerrymandered means and so on and so forth at the state level. I think sometimes we pay a lot of attention to the federal courts and to the federal Congress, which is important. We should pay attention to them. But we took our eye off of what's happening at the state and local level, which allowed these far-right actors to get into power and then to kind of push up their aims and goals to the federal level, which then resulted in the ability to capture power at the federal level and then pack the courts the way they have. So these things all work together, and they're all a project to recenter white supremacy, to take the baton that was passed to them after desegregation. That wasn't fashionable anymore to talk about segregation, and so they went to abortion rights, right? And to organize along those lines and to drive their power grab on the backs of people of color, poor people, women, and LGBTQ people. And so there definitely has been a sea change in the federal judiciary that has given permission to state legislatures across the country to pass these restrictions, including SB 8, and the fact that the Supreme Court, in the literal dead of night, refused to even stay that and let that go into effect, gives a huge warning flag to us, the movement, about what's to come in Jackson in December, and also gives a huge runway to other states, as we're seeing in Florida, for example, to pre-file or to plan to file similar copycat laws, because they've seen that sea change, and they understand that we're entering into this final movement of this symphony for us.
Okay, symphony. But thank you for that. I think it's a great visual of connecting those dots for those of us and understanding the history and the impetus of so many of these things. So my next question is to Katie. This year isn't only a significant one in terms of the legislation that's been passed, it's already proven to be a remarkable year at the Supreme Court and will continue to be so. Can you tell us about the Texas abortion ban and its status in the courts, and give us a preview of the Mississippi case the Supreme Court will hear on December the 1st?
Yeah, thank you, Tamara. Thank you, Kelsey and Renee and Sonia. I think we're all sad that we have to be having this conversation again, but here we are, and I'm glad to be here with you all. So I will try to make this quick. I think a lot of people probably have some of the details about these two particular cases. So the sort of epicenter of action when it comes to abortion at the Supreme Court right now is obviously what's happened in Texas over the past couple of months when the Supreme Court was ostensibly on vacation. So earlier this year, Texas passed what is essentially a ban on abortions after about 6 weeks of pregnancy. And that is before a lot of people know that they're pregnant. But what's particularly sinister about this law is that the state doesn't enforce it. Instead, the state has deputized literally any person to sue literally any other person who helps someone get an abortion. And the law actually encourages this sort of vigilantism by providing a $10,000 reward for anyone who sues and wins. So there are a number of cases that are being litigated to challenge this law. The one that you're probably most familiar with is Whole Woman's Health versus Jackson, where a group of abortion providers and abortion funds in Texas challenged the law's constitutionality. And as several people have alluded to, on August 30th, the plaintiffs in that case asked the Supreme Court to put the law on hold simply while the case was being litigated because the law was meant to go into effect on September 1st. The Supreme Court waited and twiddled its thumbs. And at almost midnight on September 1st, when the law had been in effect for 12 hours, issued like a very short one-paragraph decision saying, no, we're not going to step in. We're going to let this law be enforced. So it essentially has been in effect since then. As of September 23rd, that lawsuit is back at the Supreme Court on another motion for emergency relief. Meanwhile, on September 9th, the Department of Justice, under the leadership of Merrick Garland, whose name might be familiar to those people who are looking at Supreme Court controversies, so the Department of Justice challenged the constitutionality of the law too. And what's interesting about this case and different about this case than the Whole Woman's Health case is there's some question about whether the plaintiffs in the Whole Woman's Health case have sort of standing to challenge the defendants in that case. There's no question that the United States government has the right to sue the state of Texas for violating the constitutional rights of its residents and of citizens of this country. And so the good news is that as of this past Wednesday night, a federal judge has blocked the law while this particular lawsuit moves forward. We know that the state has already appealed to the Fifth Circuit Court of Appeals, and so we'll see what happens there. But we're sort of on the right track there. And then I'll just mention two other random lawsuits because this is a law that invites random lawsuits. There are two dudes in Arkansas and Illinois who have sued an abortion provider in Texas as exactly the law is meant for them to do. Neither of these lawsuits are likely to be dispositive of any of the issues, but I mention them because they are sort of illustrative of how absurd and cruel this law is. And really quickly, Mississippi, the lawsuit that is, the case that's going to be argued on December 1st out of Mississippi is much more sort of traditional. So Mississippi passed a ban on abortions after 15 weeks of pregnancy. The fundamental holding in Roe versus Wade is that a pregnant person has a constitutional right to an abortion, and a state can't ban abortion prior to the point of viability. There is no question that 15 weeks is prior to the point of viability, and there is no question that this law violates the constitutional right to abortion as articulated in Roe versus Wade. But again, the Supreme Court decided to hear the case. We'll hear oral arguments on December 1st, and we'll decide the case by next June. So that's the case in the Supreme Court. We'll see what happens, and meanwhile, we'll keep fighting.
Absolutely. Thank you for that, Katie, for that breakdown and some additional information on what's moving in the courts, which can be kind of confusing oftentimes with how things move and all that. So thank you. So Renee, your work focuses on elevating the voices of people who have actually had abortions, making sure that the people most affected by these laws are part of the conversation. How have all these laws impacted the real people who seek access to abortion, and how are things on the ground in Texas, and in which communities bear the burdens of these laws?
Yeah, thank you so much. I'll do a quick description of myself for folks who have visual impairments. I'm a biracial Black woman. I got dimples from my mama, red lip, gold glasses, and I'm standing in a room with a beige wall wearing a black t-shirt that says I had an abortion in white lowercase writing. Yes, I mean, these laws are, forgive anyone listening if you're hearing about all of these laws and you're confused because you're like, wait, which one's at the Supreme Court? What's going on? Well, that is the reality for people who are having abortions on the ground, right? They're constantly confused. Is this even a legal right? Am I going to get arrested for this? Do I have to leave the state? What do I have to do? And that's actually the point of all of these laws. They are trying to confuse people, make us feel like this is healthcare we shouldn't even be trying to get, that it is illegal, that it is a crime. And as the anti-abortion movement has always said, they want to make abortion unthinkable. And so that is how they're doing it, through the judiciary, making it extremely confusing, adding to the stigma. And it just makes the experience really, really difficult on top of community level stigma and internalized stigma that people might already be facing. What I do think is really important is that we do remember that there are people who have had, or trying to have abortions at the center of all of these cases. One of the things I've learned from all my friends who are in law school is that when you read about all these cases, sometimes those of us who are at the center of them are left out of the conversation, and you forget that all of this really does impact real people. So what we do at We Testify is work with people who've had abortions, like myself, like all of our storytellers, particularly folks of color, disabled folks, immigrants, formerly incarcerated, anyone who was really impacted by these barriers, and make real the impact that they're having. The challenge is that the anti-abortion movement has kind of said, well, these restrictions, they're not really that bad, right? I just watched an interview where the anti-abortion movement says 6 weeks, you have 6 weeks to figure it out. Well, actually it's about 2 weeks. And if you have to go to a judge to get an approval to have an abortion because you're under 18, that can take anywhere from 2 to 3 or 4 weeks. So you don't actually have 6 weeks. All of it is a lie. And so what we try to do with stories is really illustrate the ways in which the barriers are impacting our access, but also that the courts aren't always helping us in trying to access the care. Now, I'm not going to totally bash the courts. There are judges and some of the courts that are really, really critical and important, right? So obviously there was a federal judge who basically put SB 8 on hold while it goes to the circuit courts. One thing I want to point out that was super, super important is that it was in a footnote, but that judge specifically said that court recognized that some people who have abortions don't identify as women, recognizing the fact that queer and trans people have been speaking out and sharing their stories, right? So that conversation that we're having in the public is starting to show up in the courts, and it really is getting the recognition that sometimes we can't even get within our own movement. So it's really wonderful to actually see that when we do have justices who are listening to our stories and recognizing our humanity and actually putting it in the decisions, that is actually moving us closer to that arc of justice.
Yes, thank you for that. I was listening recently to someone who says oftentimes history is not told by those who are all participating. So putting it in writing to document here and now who and what is at stake is so important in this work, and telling those stories and sharing our own stories. So thank you for that. So we've just spent, for the audience, we've just spent a lot of time kind of laying out the atmosphere in which we're living, right? This can feel very dark and doom and gloomy, but we also are a group of people who believe in solutions, and that the urgency is now, and that we didn't come to this fight without a plan. So I want to kind of shift the conversation a little bit to talk about what the solutions are. And for our guests in the audience, please feel free to drop questions in the chat. We will try to address them at the end, but as we're talking, please feel free to drop some questions. So my first question on this front is for Katie. Legislation has been introduced in both the House and the Senate that would expand the Supreme Court by 4 seats. Can you briefly tell us about that legislation and why it's so important at this moment?
Yes, thank you. So yes, it is so exciting that there is a bill in the House and a bill in the Senate to add 4 seats to the Supreme Court. Truly, a few years ago, this might have been unthinkable, but there is a growing acknowledgement that the Supreme Court is way out of line with the American people, way out of line with the politics of this country, and that it's doing active damage to our fundamental rights, to our ability to pass the progressive legislation that we desperately need to pass in order to face the critical issues that in order to address the critical issues that we face, and that it is a threat to our democracy. One of the things that I talk about a lot with this is that this is a Supreme Court that is actively sort of dismantling our ability to be a democratic country. It has eviscerated Section 2 and Section 5 of the Voting Rights Act. It has given the green light for extreme and even more extreme partisan gerrymandering. It's opened the floodgates for money in our politics. So in addition to all the sort of substantive issues that the Supreme Court has put in peril, it's also putting in peril our very democracy. So the good news is this legislation is pretty simple. It's literally a line of code. Cross out the 9 justices, add 13. There is no question that it is constitutional. There's no question that Congress has the ability and, in fact, the responsibility to set the size of the Supreme Court. It's not unfounded. It's been done 7 times in our country, and so we're excited to have this introduced in both houses, and we're excited to see it move forward.
Thank you. Thank you. So Sonia, we heard Congresswoman Pressley describing the Women's Health Protection Act and making the case for why this legislation is so critical. But she also talks about the need to expand the Supreme Court. Can you say more about why you think Supreme Court expansion is important in addition to the Women's Health Protection Act?
Yeah, I mean, it's super exciting that the Women's Health Protection Act passed in the House. We still have work to do in the Senate, which requires passing or abolishing the filibuster. So this is part of a larger need to reform our institutions, right? It beggars belief that a court that is likely willing to gut Roe, or at least allow things to certainly stand that they wouldn't have, prior to the packing of the courts, would allow something like WIPA to also stand, right? If a court, and this court is driven by ideology, which we know the conservatives on the court are, their goal is not just to, put up another little barrier for us to have to continue to go to the courts again. If we don't expand the court to help rebalance it and make it actually responsive to the needs of the people, and also, frankly, fit to do its job, which is protect our rights, passing WIPA would be great and historic, but ultimately it'll run into the same problem that so many of our advances have ran into, and that will continue to run into, which is a court that ideologically is opposed to protecting our rights, and that has shown it is no longer fit for purpose as it currently stands, if we do not add additional seats to balance out the packing that Trump and McConnell did. So, WIPA is critical. It's abolish the filibuster, pass WIPA, expand the courts. Like, boom, boom, boom. That's the order it has to go in.
That's right. Our government are 3 chambers, right? And so they all need to be a part of the remedy. So thank you for that. Kelsey, one thing that All Above All says, and we've also, I think some other folks have said this today, that Roe is the floor, not the ceiling. So how is the Supreme Court already hindering the ability to expand access and achieve reproductive justice? And how will adding seats to the court fit into your vision of expanding access and equity?
Thank you. I had to find the unmute button. As I mentioned before, because of the Hyde Amendment, the promise of Roe has been virtually meaningless for folks who are low income. And I think it's worth noting that after the Hyde Amendment was passed, it was litigated up to the Supreme Court, and in a case called Harris v. McRae was ruled to be constitutional. So it's not new for communities who are working to make ends meet, folks of color, to have the courts deny access to abortion. This has been the reality for decades. And as the restrictions I mentioned earlier, we know those fall hardest on low-income communities. And, I think even if SCOTUS was to rule not in our favor on any of these cases, which shouldn't be the case because precedent is on our side. There's unlikely to be a day in this country where a wealthy white woman can't get an abortion. And so it's important to keep in mind that the courts have never really protected access for the communities we care about. And I think the ruling in SB 8 has painted a really stark picture of what could be the reality in swaths of the country. And that's presumably while Roe v. Wade is still law of the land. The court decided to not enjoin SB 8. So I just, after years of decimating access on the state level and a lack of proactive action on the federal level, until recently, thanks to champions like Ayanna Pressley, we've been left to rely on the courts to overturn these really scary laws. And I think now is the time that we need to expand the courts. We need to have justices who understand that abortion is a fundamental right. And without that, it's pretty bleak. It's really critical at this point that we are pulling all levers we can, from Congress to the White House to the courts. I think abortion access advocates have been screaming from the rooftops for a long time that we're in a crisis. And it almost feels like it can't get worse, and then it does. So we're really in a time where we need bold action from people who say that they're champions of abortion access in Congress.
That's right. We need to be bold and tenacious right now to protect and defend our communities. My last question is to you, Renee. Your organization, We Testify, is part of the Just Democracy Coalition, who endorsed court expansion in September of last year with the passing of Justice Ruth Bader Ginsburg. In your view, I'm curious to hear how democracy reform and reproductive justice are related and why the Supreme Court expansion is important for both.
Yeah, we were really proud to join just a handful of abortion access organizations, reproductive justice organizations, to endorse abolishing the filibuster and expanding the courts, because the thing is that we cannot have reproductive justice, we cannot have abortion access so long as all of these racist relics still exist within this system. It's just that simple. If we do not have the right to vote, if our systems are still gerrymandered, then we do not have the ability to elect the legislators who will actually make sure we have real access to abortion. We do not have the ability to elect senators who will then vote for justices to ensure that they will uphold our rights and the Constitution, right? It is actually just that simple. And I want to just say that people always say, oh, abortion's a divisive issue. No, it's not. It's a fucking gerrymandered one. And it is gerrymandered because of the way that our political system is set up to ensure that the people who are most impacted, the people who are treated like crap by the politicians that we currently have in power, particularly Black and brown folks, particularly people having abortions, are not able to ensure that our voices are heard. And we need to ensure that we have a Supreme Court that not only holds up the precedent that they have already set, but also protects us and protects our access. And I'll just end by saying that when it came to the case that's at the Supreme Court right now from Mississippi, Jackson Women's Health v. Dobbs, we submitted an amicus brief to the court. And the anti-abortion movement submitted one with people who've had abortions named signed to it, right? They only have 375 people. In a week, we got 6,641 people who've had abortions. It is time that the court listens to all of us. And if we do not have justices that are willing to uphold the rule of law, that are willing to uphold all of our voices and protect all of us who've had abortions, then it is time to actually change our democracy to make sure that it truly is a democracy and listens to all of our voices.
Period. Thank you.
Period.
Period, boo. Right, period, boo. So we have one question in the chat, and quickly, Zach going asked, what do we make of proposals to not just expand the court, but reform the nomination process? And there's a whole slate of other reform measures that have been proposed. And I don't think we have enough time right now, because we're already a little bit over, to give like our really good, robust question or answer to this. But yes, we think that Court expansion is just one of the tools in the chest, right? But we think it's the most urgent and necessary because of the crisis our democracy is facing. We also know that we need to have term limits. We need to talk about a code of ethics. We need to talk about so many other things that creates the real checks and balances and accountability of the least democratic body in our federal government, which is the federal courts. But also, if folks have other questions, please join us afterwards in the Demand Justice group chat room. I don't know the official name for that, sorry. But there's a room, I'll be in there, but we can talk more. You can ask me all the questions. But I just want to thank everyone today for taking some time out to learn more about why we need to expand the court in its connection to abortion rights and access, but also broadly what it means for us to have access to abortions to uphold our democracy. This is not a one-off issue. This is not a thing that we're just like, oh, tick this box, we're done. What we're saying is that this is a robust proposal because all of us are impacted. All of us know someone who's had an abortion. That's facts. If you don't, you're not talking to your people. I'm going to say that, right? So we know the society that we live in, we know the moment that we're in, and that we need to be bold and tenacious. And adding seats to the Supreme Court is how we do that. If we want to protect and defend all the good organizing people are doing right now, from voting rights to immigration reform, to health care, to job protections, we must reform our Supreme Court, because if our House and our Senate pass legislation, we already know that the Supreme Court will not uphold the will of the people, and we need a Supreme Court that will do that. And that's why we need to expand the court. So I want to thank my wonderful, wonderful, smart, dynamic, distinguished panelists today, and also Congresswoman Pressley, who opened this up and let us all know that if you feed me, you can lead me. And so next time when we're all together, we'll make sure we'll have some cake and snacks, and we can hug each other and love each other in this moment, because that's what we need more, because we have this discipline of hope and this belief of radical change through love. And so thank you all again for your time and your attention today.